your community service hours at the statutory rate. Your probation shall automatically terminate at the 3-year mark if you've successfully completed all the terms of your supervision at that time and haven't committed any new law violations. Thank you, sir. Good luck to you.
And Your Honor, there is a 6-month driver's license suspension associated with a conviction for this charge. My understanding is that that can be waived if Your Honor waives that suspension on the record.
To the state?
The state's not going to have any objection, Your Honor.
Okay, then yes, sir, I do waive that.
Thank you, Your Honor.
Thank you, sir.
Thank you. Your Honor, and then my other out-of-custody client, Frank Soska, pull up that phone, that case number here, 24 CF 671, his appearance was previously waived. State and I have failed to come to an agreement on that. We'd ask that he be set for the pretrial.
Yes, sir. September 9th at 9 o'clock.
Thank you, Your Honor. I'm just going to have a quick word with Mr. Sakandi, and I'll be right back.
Let me know when you're ready.
Thank you, Your Honor.
Thank you. Mr. Nettle.
Good morning, Your Honor.
Good morning, sir.
I will first call up Mr. Warble, judge, as I understand that after I left the other day, he came back. And I will give Mr. Warble credit because he actually gave some serious thoughts about the consequences of being on probation and the possibility that he might violate. And he and I talked last night, and I think at this point, he wants to go ahead with the plea as he originally signed it for the 36 months or, 36 months probation with an 18-month early term.
Okay.
Is that correct, Mr. Warble?
Yes, sir. Yes, sir.
Okay, so what I had was right, was 3 years probation. Standard terms after 18 months. Okay, an automatic termination at 18 months, is that what we're talking about? I'm looking at a prior plea and sentencing agreement.
It was automatically I'm sorry, go ahead.
The minute sheet of July 15th says that he already entered this plea.
We did, and he came back to court after I left.
Gotcha. Good. Thank you
and
for
said that
reminding me.
he wanted to withdraw the plea and go to jail instead because the state had offered him 6 months instead of probation.
Gotcha. So, Mr. Warble, you want to continue with this sentencing agreement? You do not want to set it aside, correct?
Yes.
Okay. So you're satisfied with this plea?
Yes, sir.
Okay. Thank you. Yes, sir. Now that you reminded me, security came to me and said, he doesn't want to do that. And I said, what do we do? So, good. I'm glad you came back, sir.
Yes, sir.
Thank you. Thank you, Mr. Nettle.
All right, Judge.
Probation?
Your
See you.
Honor, Mr. Warble needs to report immediately to the probation office.
Good. Thank you, sir.
Mr.
Thank you, ma'am. Hello, Ms. Lumis. Good, how are you?
I do have a question. I do feel like he's explained to me, or I just want to make sure that I understand what my life is what's happening here. If in turn I'm pleading to you today, would I sign a plea agreement before I plead to you, or would I just plead guilty in order to plead to you?
You would plead no contest, and then I would sentence you later. If it's a plea straight up, a plea to the bench with no agreement with the state. And then the court would determine whether it's an adjudication of guilt or not, unless that is a term that y'all have already agreed to. If it's that you've agreed that it will be a guilty plea, then I'll do that and then reserve jurisdiction and have a sentencing hearing about what you'd be sentenced to. If you don't agree to what the adjudication is, whether it's a withhold or an adjudication of guilt, then I would decide that at the later sentencing hearing.
So if I were to sign a plea agreement today, then you'd be able to sentence me today. That's correct.
If y'all want me to send, if both sides is ready for me to sentence you today, then I will. If you're not, then I'll delay it until next week or whenever they'll be ready. And any homework that you give me, I'll do that. And you can call witnesses, the state could call witnesses.
And if I'm allowed to, I know I don't want to take too much time on, I would just.
No, ma'am, this is your life. You take your time.
Thank you.
Yes, ma'am.
I would, these cups make me anxious. Would like to address the court about one more thing. In my VOP charge under statute 817568-2A of illegal use of identification, I'm attempting to do a little charge bargaining with Mr. Gomez and ask that my charge be reduced to statute 817568-2 of unlawful possession of personal identification information of another person, which is the lesser charge. Mr. Gomez, I just want you to know there was never any ill intent or financial gain, just the ridiculousness of impulsivity. And when asked for an ID, I placed an ID on the counter that I had found on the ground in the parking lot. During the run of the jet ski, that was also returned on time. I'm kindly requesting that you wholeheartedly consider this matter, that today we might come to a resolution. Please, sir, maybe reduce my charge.
Mr. Gomez,
I understand what she's asking. I've already considered this. I mean, Your Honor, just so that you're aware, I don't want you to think that the state is just being hard. We already agreed to reduce it from a suspended sentence of 48 months down to this cap.
and what is the cap?
33.45 months, Department of Corrections. And so, you know, at this time, Your Honor, that's going to be the state's final offer.
If I would just say one more thing, and then I will rest at that. Originally, the 48 months, I didn't even score to that when I took that, no fault of your own, but I didn't even score to that. And at the time, even if the points would have been right, it would have not only, but at least less than 58 points. And I'm just saying if you maybe would consider that also. Thank you.
Okay. Thank you, Ms. Lumis. So, Ms. Lumis, do you wish to enter the plea without an agreement with the state on what the sentence would be, other than there's a cap of, and it's 33 point, how many months?
4 or 5 months, Your Honor.
Okay. And that's in prison, correct?
That's correct, Your Honor.
Okay. So, Ms. Lumis, do you have a written plea agreement?
We have a written plea agreement that states that, Judge.
Okay.
I don't, Ms. Lumis was talking to me back there about the plea agreement. I just explained to her that, you know, normally the plea agreement has to be documented on a felony case.
Right.
That's why we need her to sign it. She felt like signing it would be an admission of guilt, which I don't know. I mean, she's going to plead no contest, which is not necessarily an admission of guilt. Signing it's not an admission of guilt. It's just acknowledging that you've read the plea form and understand it.
In the plea agreement, does it have adjudication checked on that box?
Well, I'm assuming that she'll be adjudicated. She's has convictions in the past. So.
Okay, Ms. Lumis, let's do this, because you feel uncomfortable with that. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You can put your hand down. Ms. Lumis, are you currently under the influence of any drugs, alcohol, or medication?
No.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
Been treated for, but not suffering currently.
Okay. Are you currently prescribed any medication for that condition?
No.
Okay. So, Ms. Lumis, because of that, what are you entering a plea to? What are the charges against you?
All of my charges? Well, right now, I believe I'd just be entering a guilty plea to a VOP.
Okay. And then what would be the cap of how much you could be sentenced to in prison?
33.4, I believe I just
33.45 months in prison, correct?
Yes,
Okay. Do you understand that you'd be waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you?
yes,
Okay. Has anyone forced, threatened, or coerced you into entering the plea?
no,
Has anyone promised you anything other than the cap of 33.45 months in prison?
no,
Do you have any questions for me or Mr. Nettle or the state?
no, sir.
Okay. Ms. Lumis, how far did you go in school?
Half the seventh grade.
Okay. Ms. Lumis, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel. I do find that there is a factual basis for the entering of the plea. So as far as sentencing, today or some later time?
I think, if I'm not, I don't want to speak for Mr. Nettle, but I think he may try to argue some mitigating factors. I think it needs to be set for probably the miscellaneous date. The state's not prepared to argue for sentencing right now, Your Honor.
Okay.
That's
So-
fine, Judge, we can.
How far out do you want to set it?
Well, let me, as you know, I sent you a copy of Dr. McDonald's report and a copy of the program that has accepted Ms. Lumis. However, they had a bed open that they said they would hold it open till the end of today. If we set it out.
And that is
it should
where,
have-
because I haven't seen that. Where,
I emailed you all that information, and you sent me a thank you email back.
okay, and I don't have it printed off for some reason. It may have been, well, I don't.
I can email it all to you again, Judge. I mean, it's not a problem.
Okay, where was that?
It's out of the Lakeview Center over in Pensacola.
Yes, sir.
It's called Road to Recovery, part of the Lakeview group.
Okay. And so your concern is that, well,
Well,
to the state.
I mean, if you agree to sentence her to that program, then she will just be bars to bed.
Yes, sir.
I
Good.
mean, I don't know if she could have got out of jail in time today to get there, because they were,
I've already talked to a caseworker, and they would give me a transport, and they're already willing to pick me up as soon as I call them.
Okay.
her caseworker is, but if you haven't read the material, maybe it's best that we set it out. I'll subpoena Dr. McDonald to come in and testify.
Okay.
I mean, she's prepared a report, which I'll email you her report and the recovery program's information. And I will have Dr. McDonald here to testify on behalf of Ms. Loomis.
Ms. Lumis, I think the more information I get, the better decision I'll make. So I think it's in your best interest for us to wait.
So then that alleviates the program that I worked to.
No, you're still.
I know that you're approved for the program, and that's the big thing. As far as when a bed becomes available, then it would be the next time a bed becomes available. So the next date I have is August 12th, unless the state tells me that we're not going to try anything on Friday, August 9th. We can do it that day if y'all wanted to.
I think August 12th, isn't that Judge Ketchell's?
Probably, yes, sir.
Let me check here.
It would be in the afternoon then, Mr. Nettle, so that might be,
What's that?
since it's gonna be a hearing with witnesses, we'll probably have it in the afternoon of August 12th, so that will allow you to be able to,
It would be at 1:30.
you'd be able to go to court in the morning with Judge Ketchell and then this in the afternoon.
August 12th in the afternoon would be all right, Judge. I have
Okay.
a hearing here in the morning, but I guess I can.
Okay. Ms. Loomis, I'll see you on August 12th at 1:30. I'll do my homework, okay? Thank you, ma'am.
And I think I'm pretty sure I emailed you everything because you responded back and said thank you.
Okay.
I
And I
think
just,
that's it, Mr.
those copies didn't make it to me, and I apologize.
Okay, well, I'll make sure that they're attached. I thought I attached them, but,
No, and I'm saying, I didn't get the copies and put them here, so it's my fault.
oh, okay.
Not yours. But if you'll send it again, that'd be great.
Mr. Jones, did you get the email I sent to you?
Believe I did.
Okay. All right, thank you, Judge.
Thank you, sir. Mr. Shaw?
Morning, Judge.
Morning.
Tim Shaw. First, I should probably cover Miss Sarah Oberlison's case.
Okay.
So I don't forget it. She has,
Yes, Your Honor, on this case, I spoke with Ms. Oberlison on Tuesday, I believe.
And it's Jaden Miller, 24 CF 3, God bless you,
That's correct, Your Honor.
362.
correct.
It came to our attention that she may not have had one of the body cameras, which was quite important in terms of her understanding of the case. So we've agreed to continue this, I believe, Your Honor, to September 9th with the understanding that we're still working towards an agreement, and if we can come to one during that August, or September 9th. But if we can come to one for one of those August miscellaneous days, then we'll docket it for that and get a resolution.
Mr. Miller's case is continued until September 9th.
Thank you, Judge. Judge, Tim Shaw for Shenley Tan, that's 23 CF 1319. We have a written plea agreement, Judge, may I approach?
Yes, sir. Morning, sir.
Judge, if you'd like me to announce the terms, I can do that. I know my writing sometimes isn't the easiest.
Yes, sir, if you would.
Judge, again, before the court is Shenley Tan, case number 23 CF 1319. At this time, she would withdraw her previously entered plea of not guilty, tender a plea of no contest. As to count one, it will be to the lesser included offense of leaving scene with injuries, which is a third-degree felony. 36 months probation with automatic early term at 18 months, provided no violations and all conditions are met. Fines and court costs as required by statute or ordinance, $40 a month cost of supervision, one session of the victim impact panel, and reserve on restitution for 90 days. Excuse me. Count two would be to the lesser included offense of DUI with non-serious injuries, which is a first-degree misdemeanor. It's 12 months probation concurrent with count one, 36 months driver's license revocation, DUI school, 50 hours community service work. We'd ask the court to allow buyout at the statutory rate. One session of the victim impact panel, which would be concurrent with count one. Fines, costs as required by statute or ordinance, and the court would have no objection to a business purposes license. There's also a 10-day vehicle impound, Judge.
Okay, thank you.
Oh, and I'm sorry, the adjudication would be withheld on the felony, count one, and she'd be adjudicated guilty on count two.
Thank you. Ms. Tan, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Tan, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. Tan, I do accept your plea. Adjudication is withheld on count one to the lesser included offense. You're sentenced to 36 months probation, which will automatically terminate at the 18-month mark if you've successfully completed all the terms of your supervision and haven't committed any new law violations. You'll need to pay the court costs, $40 per month, cost of supervision, attend one victim impact panel. Court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a motion or a petition within 90 days from today. Count two, you're adjudicated guilty of the lesser included offense, the misdemeanor. You're sentenced to 12 months probation. That's to run concurrently, run at the same time as the 36 months. It was a 36-month driver's license revocation. You need to take the DUI school, attend that, and successfully complete it. You can obtain a business license. The court has no objection to you obtaining that if you qualify. You'll need to perform 50 hours of community service work. You can pay that off. You'll need to pay the court costs, 10-day vehicle impound, and again, you'll have to take the victim impact. But that's concurrent with count one, so you only need to do that one time. Thank you, Ms. Fan. Good luck to you, ma'am.
Judge, may I approach briefly?
Yes, sir.
Please give us a call. We're here to help you out.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestviews historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
Yes, sir. Thank you.
We're located.
Mr. LaPella, you ready? Not yet, Judge. Okay, let me know when you are. Mr. Garrett?
Yes, Your Honor. Your Honor, excuse me, client is Mark Sakandi. He's an inmate, 23 CF 1956.
Yes, sir.
He's making his way out.
Hello, Mr. Sakandi. Good morning.
And Your Honor, the state and I were unable to come to an agreement here. We'd ask that Mr. Sakandi be set for August 12th for hopeful resolution.
Okay, so we're going to continue the underlying case until September 9th and set it for a status conference on August 12th.
Yes, Your Honor.
Okay. Mr. Sakandi, I'll see you on August 12th. Thank you, sir.
I believe that's all I have, Your Honor.
Thank you, sir.
Have a good day, Your Honor.
You too. Okay, I don't see any other private counsel. I don't think there. Okay, oh, good, yes. Mr. Upperman. Thank you, Madam Clerk.
Good morning, Your Honor.
Good morning, sir.
Your Honor, I'm here on State v. Stoffel, case number 2014 CF 1876. I waived Mr. Stoffel's appearance. This is a pending Rule 3.850 motion. As I told you in our last status conference, Ms. Basso and I have been attempting to work out this case. I'm still hopeful we're going to be able to reach a resolution. We're still in the process of scheduling a face-to-face meeting to get that accomplished, and we're juggling her trial schedule and our summer schedules. I'd ask that this be set back 60 days, and I am very hopeful that by then we will have a resolution to announce to the court.
Okay, so September 19th?
Perfect, Your Honor.
For September 19th. And do you want it in the morning, or are we doing it in the afternoon? Because you're going to have evidence.
Well, let's just, if it could be a status conference, Your Honor, and then if we do need to proceed with an evidentiary hearing, then we can pick a date at that time.
Okay, yes, sir. September 19th at 9 o'clock.
And Mr.
Perfect.
Offerman,
Thank you.
Mr. Offerman, just so you're aware, I did discuss this with Ms. Basso yesterday. She apologized if she missed her call, but she'd asked that you two try and get in touch the next few weeks. She does have some information for you.
Very good. Yes, I'm trying to get a hold of her, so thank you for passing that along.
Perfect, thank you.
Thank you, Mr.
Okay, thank you, Your Honor.
Okay, let me make sure no pro se's. I don't see any. To the PD?
Your Honor, can we do Mr. Nguyen on
Sure.
Zoom?
Yes, sir.
Your Honor, this is Hui Nguyen in 23 CF 1839. We have reached an agreement with the state to resolve this. Mr. Nguyen is going to be entering a no contest plea to the lesser included offense of simple battery. The agreed upon disposition is that he will be placed on 1 year of probation. That will be supervised by JCS, and I will contact Mr. Nguyen today with contact information for JCS. He's one of the better clients I've ever had in answering his phone. The special condition is that he will complete an anger management program, submit a letter of apology to James Atkins. He would be assessed misdemeanor court costs, a $50 application fee, a $100 public defender fee. There would be an adjudication of the misdemeanor. When I hand the plea agreement to Your Honor, you're going to see 2 signature pages. I had emailed Mr. Nguyen the plea agreement so he could read it and sign it, and he emailed me back just the signature page. So there's a duplicate signature page on this plea agreement. May I
Thank you.
vote?
Yes, sir. Thank you, sir. Mr. Nguyen, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Mr. Nguyen, did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, Your Honor.
Did he answer all of your questions?
Yes, Your Honor.
Are you satisfied with his representation?
Yes, Your Honor.
Did you sign the plea agreement?
Yes.
Mr. Nguyen, I do accept your plea. You're adjudicated guilty of the lesser included offense. You're sentenced to 1 year. Is 1 year probation or
It's 11/29 probation.
11 months, 29 days probation. JCS will supervise that. You will need to do the letter of apology, pay the $150 public defender's fee, and pay the court costs. You will need to enter and successfully complete an anger management program.
Yes.
Thank you, Mr. Nguyen. Good luck to you, sir.
Thank you, Your Honor.
Mr. Nguyen, hold on one second. The clerk says they need fingerprints from you. How are you going to do that, Mr.?
Just make it as a condition of probation.
Good. So, Mr. Nguyen, you'll have to give your fingerprints to probation, okay?
What I'll do is I'll call you later today or tomorrow and give you the contact information for JCS, and I'll explain to you how to get those fingerprints taken, okay?
Thank you.
Thank you, sir. Okay, who's next?
Judge, I have Lieutenant Walls. Mr. Walls is on Zoom. Mr. Walls, can you hear me okay? Mr. Walls, could you start your video and unmute?
Yes, sir.
Jason McKinney on behalf of Mr. Walls, 24 CF 1066. I sent confirmation of the restitution payment to Mr. Snell. I believe that the state's in the position or has already filed a null process in this case.
We have. It hasn't come through the portal yet. Mr. McKinney and I both spoke with the victim in the case, and restitution has already been made. So
Okay.
at this time, the state would announce a dismissal in 24 CF 1066.
That case is dismissed, Mr. Walls. Thank you, sir.
Yes, sir. Thank you.
Thank you, Judge.
Okay. PD, who's next?
Judge, you have one in the courtroom.
Yes, sir.
If I may call Mr. Gary Rollison, who's present, approaching.
Yes, sir.
Good morning, Judge.
Good morning.
We're here in 23 CF 2199. My office did send over an order and a motion to withdraw due to conflict.
Okay.
And I believe in the court file, my client retained a private attorney. there should be an NOA. I did discuss it with his private attorney. I believe it's Mr. Ricky, is it?
Mr. Durham?
Yes, and speaking with him yesterday, Your Honor, he's requesting to one cycle continuance with state charge continuance due to the new evidence and potentially new witnesses on board in this case.
Okay. Any objection from the state?
No, sir.
Okay. So, Mr. Rollison, I'm putting trial next time because we had talked about plea or trial for today, but I did have the note about the new discovery. So I'll see you back here on September 9th at 9 o'clock with Mr. Dyer. Thank you, sir.
That's all I have in the courtroom, Judge.
Thank you, Mr. Cott. Mr. Kleins, anyone in the gallery?
Yeah, if we could call James Heim.
Yes, sir.
Mr. Heim is signing the plea right
How are you? Good.
Your Honor, Mr. Heim is going to be entering a plea today. He has 3 current cases. He has 21 CF 3126, 21 CF 3153, and 21 CF 2309. Both 3126 and 3153 cases are related to each other. They are the same offense dates, pretty much the same temporal. The facts in the 3153 case happened immediately preceding the facts in the 3126 case. The reason I'm bringing this up, Your Honor, is I talked to Mr. Gomez about this, and the state would be okay if the court would accept an or tennis motion to consolidate the 3153 case into the 3126 case based on the fact that these are same offense dates, the same basically criminal episode.
Yes, sir. That motion to consolidate is granted.
Now that that's happened, Your Honor, Mr. Heim is going to be entering a plea in 21 CF 3126. On the original information, Your Honor, there are 2 counts of aggravated.
So just for the record, so 21 CF 3156 is consolidated into 21 CF 3126.
3153 into 3126. Yes, sir.
3153, correct. Okay.
On the original information in the 3126 case, there are 3 counts. 2 counts of aggravated assault on a law enforcement officer and 1 count of fleeing and attempting to elude. Mr. Heim is going to enter a no contest plea on count 2 of that case and count 3. Count 1 will be null prost. The new charges that are in there, the 3126, all of those leaving the scene of an accident from the 3153 case, are going to be pled to misdemeanor leaving the scene of an accident with property damage. On those misdemeanor counts, Mr. Heim is going to be sentenced to credit for time served. On the felony,
adjudicated guilty.
yes, sir.
Okay.
On the felony counts, Mr. Heim is going to be sentenced to 18 months in the Department of Corrections with credit for all time served. He'll be assessed a $50 application fee, a $100 public defender fee, $615 in court costs, and there is a mandatory 1-year driver's license suspension based on count 3 in the original information in 3126. In 21 CF 2309, Mr. Heim is going to enter a plea as charged. On that case, he will be sentenced to 18 months in the Department of Corrections with credit for all time served concurrent to the 18 months in the 3126 case. In the 2309 case, there also will be a $3,500 final, or I'm sorry, $3,500 restitution to Barbara Reno. That will be reduced to a final judgment. Mr. Heim would be assessed another $615 in court costs and a $100 public defender fee, and he would be adjudicated on all of the counts. Mr. Heim has requested, and the state has no issue with this, and just don't know how the court's going to feel. He's asking the court to defer the sentencing to August 22nd. And I have talked with him and explained to him the mechanics of what happens if you fail to appear or you pick up new charges in the meantime. And on August 22nd, Mr. Heim is going to request that the court allow him to report to jail on August 27th. Essentially, Mr. Heim has a 2-year sobriety.
Okay, let me stop you.
Yes,
Can't
sir.
do that.
Okay.
Because once I do a DOC sentence, I lose jurisdiction.
Well, I just throw this out, I was looking at the calendar. August 29th, Thursday, 12:30, we have pre-trial detention hearings. We could potentially just fit him in there. I think that would work with his sobriety party, as well as allow us to go ahead and impose the sentence and then him be taken into custody immediately, Your Honor.
Well, you can do that on August 22nd on just
Well, the
regular
issue there
court.
is he has a sobriety, I believe he has his sobriety party.
The 25th, which is a Saturday.
Okay, I thought
Yeah,
you
that's-
said you wanted him sentenced on the 22nd.
Well, I had kind of explained to Mr. Heim, like, I can get you as close as, and I told him, I said, it's
I got
very
you.
rare to.
If the state agrees to the sentence being imposed on August 29th at 12:30, then we can do that.
That's ideal.
Okay, I just want to very clearly understood that if he does not show up, then this plea will turn into a plea to the bench, in which he has a rather high exposure.
What is his maximum sentence if he doesn't, if I don't enter this sentence?
It essentially would be 29 years. Your Honor. That, where I'm getting that from is count 2 in the 3126 is a second-degree felony, count 3 is a third. The 2309 is a third-degree felony, and all of the counts from the 3153 case would be first-degree misdemeanors. So if the court had to run everything consecutive in that situation, you'd be looking at 29 years.
Mr. Gomez, you agree with that?
Yes, Your Honor.
Okay. Mr. Heim, if you'll raise your right hand.
May I approach?
Please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Heim, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
College.
Good. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Just concerned a little bit with time share, or time.
Credit for time served?
Yeah, that would go towards my sentencing.
Absolutely.
Okay.
Yes.
I'm
Yes,
good
sir.
with that.
Okay. Any other questions?
Let's get my 2-year chip.
Okay. Did you sign the plea agreement?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering the plea? Has anyone promised you anything other than what's in the written plea agreement? Do you understand, Mr. Heim? I am going to defer the sentencing until August 29th at 12:30. If you fail to appear, then your plea agreement becomes basically straight up. It's an agreement that you could be sentenced up to a maximum of 29 years in prison. Do you understand that?
Yes, sir.
Okay. Have any questions for me or Mr. Kleins or the
No,
state?
sir, he's done a great job.
I'm sorry?
He's done a great job.
Okay, good. Mr. Heim, then I'll see you on August 29th at 12:30.
Okay, that's it. Thank you.
Do you know that statute number for the lesser included?
I'll give that to you.
What is it?
The statute number for the lesser included for the accounts, it would be 4 through 7 after it's consolidated.
I believe it's 316061.
Madam Clerk, I'll double check that.
Okay. Mr. Beck? Yes, sir.
Mr. Christopher Smith, as President approaching, Your Honor, this was, it's not on today's docket. This is in 24 CF 929, if we may
Okay.
address it.
Yes, sir.
Your Honor, this was, it was a first time up, pretrial on July 8th. My client did appear that morning, and it was on, I apologize. My notes, I did waive his appearance when he showed up, but I informed the court I did not. So it's on my fault on this one,
Did
Your
I
Honor.
issue a capias against
It
you?
is. I'm asking if we could withdraw, and if we could set him on the September 9th. Like I said, this was the first time up on July 8th.
Mr. Smith, I do withdraw the capias so they won't arrest you for this, and I'll see you back here on September 9th at 9 o'clock. I apologize for any anxiety that you had.
My bad, it was just a little frightening.
Yes, sir, I'm sure. Thank you,
I was
sir.
told the 9/9/24, and then I had a warrant. And I was like, whoa.
I'm glad you're here. I'm glad they didn't arrest you before today.
Thank you.
Thank you.
Just make that appointment,
All right.
Mr. Smith.
Oh, thank you.
Yes, thank you, Judge.
Thank you. Okay. Hello.
Your Honor, may I just know what you sign up?
Yes, sir.
Okay. Is this for you? Who is this? Oh. Okay. But no, this is something we can address with the court. Your Honor, we have a plea agreement that will ultimately place my client on probation and send her to the recovery program at Joanne Burge Women's and Children's Center. I have never dealt with this recovery center before, but I've been in contact through email, and the state attorney has also been CC'd on those emails. A concern my client has, and I also have a concern, it's ordered bars to bed, because certainly the plea is to send her immediately to the program. But my clients informed me that they do not do pickup. So that bars to bed, I don't want to put her in a situation where...
So then we just need her mom, who is in the gallery waving her hand. Then we'd have the jail release Ms. Robinson to her mom, and then her mom would need to take her directly to that recovery center. Okay. Do they have a bed available for Ms. Robinson now?
Yes.
Yes, yes, they do, Judge. The correspondence, I did not specifically see that, but...
Okay. Her mom's standing up. Do you need anything from her?
Would I?
Yes, ma'am. What's your name?
My name is Cheryl King.
Come on up, Ms. King. There you go.
The last conversation I had with Joanne Bridges, which was pretty much all evening last night, and the problem is they don't transport.
Yes, ma'am.
So we were kind of in dilemma because we have family in Crestview, we have, anyway, if she could be taken to Joanne Bridges as soon as possible, like today, if we would get her out of jail tentatively and get all the paperwork over there, they'll take her right now. But
Okay, good.
the earlier, the better.
Certainly.
Your Honor, we need
Yes.
a time that she's going to be picked up at the jail and a time that she's going to be checked into the place.
Well, I don't think that we're going to be able to say a time that she's going to be, because we don't know what transport, how soon she's going to be back there.
Well, my concern is that there'll be a detour. And
Understand.
so I want to make sure that the court can put some restrictions in there to make sure it's a straight from the jail to the.
And I understand that.
I agree. Yes, ma'am, probation.
If she's being put on probation, she also has to come by our office. So even if you take her there tonight, in the morning, she'll have to be brought to our office to check in.
Okay, how do you traditionally do it on a bars to bed?
Well, if we have time, we get up there, and they have to get out of the jail, we can talk to the Funiac Springs to see if she can check in there, since it's right there by the Joanne Bird Center. So we can get the paperwork ready and send it to the Funiac Springs and ask them to instruct.
So you need Ms. King to take Ms. Robinson to probation.
Well, she
and
can go
then-
to the Joanne Bird Center tonight, if they let her out tonight, and then in the morning, someone's got to bring her from Joanne Bird to the office.
At 8 o'clock.
Okay, excuse me, but Joanne Burgess needs her there like by 2 o'clock, because I guess it's a lengthy intake process, like physicals and all that. So, even if I can take her tomorrow or But no, tomorrow won't work either. We need to get you there today. Time is of the essence.
Well, you know, I can't tell you that the jail's going to process her out and you're going to be able to pick her up and then get her there to the recovery center by 2 o'clock today. I just can't tell you that. Mr. McKinney, and maybe what's figuring into what you're saying, the only uncertainty is how long it takes the jail to process her out.
Correct, and that's
We can
exactly
take that out of the equation if we do it tomorrow. If we say, Ms. King will pick up Ms. Robinson at this time tomorrow, and then take her to probation at this time tomorrow, and then immediately after that, take her to the recovery center. I mean, then we can take the variable out of it if we want to.
Okay. That's fine too.
Do that? Okay.
Instead of trying
The
to,
question to probation is to make all that as seamless as possible. If she enters the plea today, can that be sent to the FUNIAC for her to report in the office in probation in the FUNIAC tomorrow?
Yes, ma'am.
Email them as you speak.
At what time do you want her into FUNIAC tomorrow?
I believe she's getting confirmation that.
8 o'clock?
8 o'clock, we'll tell them 8 o'clock.
Okay. Okay. So what would happen if the court enters the plea is that Ms. King would pick up Ms. Robinson at 7 o'clock, 7:30? What?
it's Crestview?
Yes,
Yeah.
ma'am.
And transport, yeah,
So 7:30?
that's fine.
And then you'd have to take her directly to probation to be there by 8 o'clock. And then you'd transport her from probation to the recovery center immediately after probation.
Okay,
Okay?
that's fine.
Okay. Thank you, Ms. King, if you'll step back. Thank you. Ms. Robinson, a lot of people trying to make it work for you.
Thank you.
Everybody believes in you. We know you can do it. Okay.
Thank you, Your Honor.
Yes, ma'am. Mr. Koch?
Yes, Your Honor, I'm just going to correct my plea form. I crossed out the bars to bed that I insinuated there. And thank you for everyone for all that help. I know there's a lot of moving pieces there. So the plea today, Your Honor, I'd first like to address count 1 is going to be the lesser included of sell, manufacture, deliver, or possess with the intent to sell, manufacture, deliver a controlled substance. And that's Florida Statute 893.13, sub 1, sub A. All remaining counts remain the same. So for counts 1 and counts 2, adjudication of guilt. There'll be 4 years standard probation with the $40 per month cost of supervision, $615 court costs, $150 defense costs. Successfully complete the residential recovery program at the Joanne Bridge Women and Children's Center. No possession or consumption of alcohol, no possession or consumption of drugs without a valid prescription, random breath tests, and random UAs. Your Honor, there's also a 5-year suspended DOC sentence on this. All counts to run concurrent, and with counts 3 and counts 4, the misdemeanors are adjudicated guilt, credit for time served. If I just have a moment for my client to sign. Right there. And today is the 18th. And as I stated, I crossed out the bars to bed. If you can just initial next to that.
Yes.
All right. If I may approach, Your Honor.
Yes, sir. Ms. Robinson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, ma'am. You can put your hand down. Ms. Robinson, did you read the plea agreement?
Yes, sir. Yes,
Do,
Your Honor.
do you understand it?
I do, yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes, he did.
Are you satisfied with his representation?
Absolutely, yes, Your Honor.
Did you sign the plea agreement?
Yes, sir.
Ms. Robinson, I do accept your plea. You're adjudicated guilty of the lesser included offense, count 1, as charged in the other counts. You're sentenced to, on counts 1, let me make sure I get this right. On counts 1 and 2, you're sentenced to 4 years probation. You'll need to pay the $40 per month cost of supervision. However, that will be waived while you're in the Joanne Berg Women and Children's Center. You need to pay the court costs, $150 public defender's fee. You need to enter and successfully complete the residential recovery program at the Joanne Berg Women and Children's Center. That's, and when it says residential, that means she lives there and it's overnight, correct?
Yes, Your Honor, inpatient.
Mr. Robinson, you'll have no possession or consumption of any alcohol or any drugs without a valid prescription. You'll need to submit to random breath test, random urinalysis. You'll be released from the jail tomorrow morning at 7:30 to your mom, to Miss King. Your mom will take you directly to probation. You'll be there no later than 8 o'clock tomorrow morning. And then immediately after probation, you'll need to go directly to the Joanne Berg Women and Children's Center. Other than your lack of control of getting out of the jail at 7:30, everything else, the burden's on you, okay? Can't hold your mom in contempt because she's not a party to this. So you need to make sure that you're there. If you're not, then you can be held in contempt of court, okay?
Yes, sir. Yes,
Thank
sir.
you, ma'am. We all wish you the best.
Thank you so much.
Thank you,
So
ma'am.
as far as the release, what do you want my minute sheet to say?
Released at 7:30 tomorrow morning.
To anyone specific or just?
To Miss King. Miss King, what's your first name?
Cheryl.
Cheryl King.
C-H-U-R-Y-L.
Thank you. And to probation, does my minute sheet need to reflect anything as far as reporting to the Defuniac office?
I'll be emailed them.
Okay, perfect. Thank you.
Yeah, I got it.
Thank you, ma'am. Good luck to you. Okay, yes. You're Mr. Wagner?
Wagnon.
Wagnon. Mr. Wagnon, do you have an attorney?
No, sir, not yet.
Okay. You don't know your case number by chance, do you?
Your Honor, Mr. Wagnon was pretty quick to notify my office that there was a mix-up, and so.
So was a capias issued for Mr. Wagnon?
I believe so.
Okay.
I make sure that.
Mr. Wagnon, the capias is withdrawn, okay? So the,
It's 24 CF 713. Raymond Wagner?
okay, and Mr. Wagnon's not represented by an attorney?
Correct.
Mr. Wagnon, do you wish for the public defender to represent you if you qualify financially?
Yes, sir.
How much money do you make per month?
Well, I just started a new job. I'm not really sure on all that yet.
Okay, how much have you averaged making per month over the last 3 months?
Nothing in the past 3 months. I haven't been
Okay.
employed.
I do appoint the public defender to represent you. Mr. McKinney's approaching on your right.
Judge, I'm providing my contact information this time, and this is scheduled for September 9th for pretrial. Is that accurate?
This is a new case?
Yes, Judge.
Okay. Yes, sir. Mr. Wagnon, I'll see you September 9th at 9 o'clock. Stay in touch with Mr. McKinney, okay?
Give me about a week, and then call and schedule an appointment.
Thank you very much.
Mr. Wagnon, thanks for coming. Thanks for not burying your head in the sand and coming.
Thanks for not cuffing me up.
Yes, sir. Who's next? Okay. Okay, and then we have Mr. Cobb on Zoom too. Good.
Once we get these out of the I'll call.
Yes, ma'am. Good, thank you.
Morning, Ms. Parson. Judge, we're here on 3 cases, the 23 CF 1629, 23 CF 1952, 23 CF 2766, Your Honor.
Okay, yes, sir.
Your Honor, just an update. I spoke with my client yesterday. We received our counter, Phoenix program.
Yes, sir.
That will place my client ultimately in the Phoenix house. The state does wish to contact the victim to just iron out restitution. So our stance is this will be a plea. We have it all ready set in front of us, but The state's requesting the next date in August.
Do you want to do it on a week from today at 12:30?
Yes, Your Honor, that's fine.
Is that okay? Because, Mr. Parson, I don't want you sitting in jail any longer than you have to. I'd rather you be at Phoenix House.
Yeah.
Okay? So I'll see you a week from today at 12:30.
Okay.
Thank you, sir.
We talked about Mr. Parson. Thank you, Judge.
Thank you. Hello, Mr. Richardson. Good, how are you, sir? Good.
Yes. Okay, but everything else still stands. Your Honor, may I have a brief moment?
Yes, sir.
Good morning, Mr. Richardson. You can sign. Your Honor, just to make the court aware, we have a confirmed deal. It's just when the credit time will start. In this case, my client was arrested in Santa Rosa. Hold was placed on, but I believe
Was he on hold only for this case?
Yes, Your Honor.
Okay.
He was over in Santa Rosa. So I don't calculate the time, so I'm always wary on giving exact dates. But I believe it's the 4/9 date that they're calculating from of when he was brought over to Okaloosa. But as I told my client, I do not make that call, and there's nothing stipulated at this time.
Well, and that's the question to the state. Is there any time that you would give Mr. Richardson credit from that time forward?
He was incarcerated in, did he say Escambia or Santa Rosa?
Santa Rosa, I believe.
And then,
Mr. Koch, can you tell from your records when he was transported to the Okaloosa County Jail? Mr. Koch, you said he was transported to Okaloosa County on April 9th?
Yes, Judge, and my clients told me he was arrested in Santa Rosa, December 15th, of course, 2023. Hold was placed on him. I'm unsure on the exact date on that.
He was sitting in the Santa Rosa County Jail on this case from December to April 9th?
yes, the agreement that we had is that he gets time from when he was served and arrested on this charge. That's when it starts, when he was arrested on his Okaloosa charge.
Okay. When was that? Do we know?
Gotcha.
If he was arrested on December 15th, I would sure be baffled about why it took so long for him to be transported.
Judge, if you give me one moment, I'm going to research this on Santa Rosa.
Please, yes, sir.